Luis Martinez is going to run a little late. He has an MTR that he's finishing up on.
Do we have a court reporter today?
Oh, don't tell me we don't have. He's here.
Yes, sir, I'm here.
I don't. There he is.
All good. And Miss Corley, we were worried about you. We thought perhaps alien abduction had grabbed you yesterday. You signed in briefly and then we're gone.
Yes, I was having technical problems and I did have a lot of ports and I was doing multiple Zooms, but I couldn't seem to get logged into yours. I apologize, Judge.
No problem, not your fault. Okay, good afternoon, ladies and gentlemen. Welcome to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. Today is our plea docket. It is approximately 2 o'clock on Thursday, the 7th of October, 2021. The cases we have set today are State of Texas versus Lee Holbrook, cause 575509, which is a motion to revoke community supervision. We have plea docket set for State of Texas versus Benito Villegas, cause number 632458, represented by Judge Russell Mitchell. State of Texas versus Jonathan Mariscal, cause number 655640, represented by Mr. Gammon Gwynn. Cause number 652638, State of Texas versus Roxanne Monroe, represented by Mr. Gary Hillier. Cause number 666408, State of Texas versus Leo Cuello Villa Valencio, represented by Mr. Brent Hardy. Cause number 638844, State of Texas versus Kevin Hogan, represented by Mr. James Rickerson. Cause number 663603, State of Texas versus Joseph Hernandez, represented by Mr. Floyd Rivera. Cause number 655258, State of Texas versus Alex Lobig, represented by Mr. Michael Valachek. Cause number 662066, State of Texas versus Joshua Sanchez, represented by Mr. Luis Martinez. Cause number 640783, State of Texas versus Miguel Vieira, represented by Mr. Ross Brendel. And we have a Bexar County Veterans Treatment Court Track 1 pretrial intervention and probation agreement. Cause number 656343, State of Texas versus Reynaldo Salazar, represented by Mr. Roberto Vargas. And Ms. Corley, are you ready to proceed on Mr. Holbrook's case at this time?
Yes, Your Honor.
Okay. This is cause number 575509, State of Texas versus J. Lee Holbrook, represented by Ms. Linda Corley. Representing the state in all matters today will be Assistant Criminal District Attorneys Guillermo Flores and Megan Galloway. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Mr. Holbrook's case, cause 575509, is a second amended motion to revoke community supervision. Mr. Holbrook and Ms. Corley, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signatures on it. In fact, Mr. Holbrook, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Corley, as attorney for Mr. Holbrook, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Holbrook?
Yes, sir.
Thank you. And Ms. Corley, as attorney for Mr. Holbrook, is this also your signature on this document?
It is, Your Honor.
My understanding, Ms. Corley, is that this second amended motion to revoke community supervision is uncontested. Is that accurate?
Yes, we were having a plea of true with explanation.
Fair enough. Mr. Holbrook, in cause 575509 on the second amended motion to revoke community supervision, how do you plead, sir?
True with explanation, sir.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Holbrook's probation, please?
Yes, Your Honor. Mr. Holbrook has performed poorly on probation. We last saw him on September 21st of 2020. He missed his last 4 months of reporting. There was no effort to make any payments. He has a balance of $1,240. The case did expire January 12th of 2021. His community service was probated for military service. He had one positive drug result for methamphetamines and amphetamines. This, however, was not confirmed by the defendant. nor has he provided any medical prescription documentation. He failed to submit to drug testing on 5 occasions. We have no proof of completion of a CATSNP program. His criminal history includes arrests for unlawful carrying, DWI first, driving while privileges suspended, DWI second, possession of a controlled substance, penalty group 2, less than 1 gram. His officer is recommending that his probation be revoked, or should the court consider continuing him on probation, they recommend that he go to SATF followed by aftercare, and he would need an extension in order to do that.
Do I have the authority to keep him on probation? Like you said that this case had expired.
It has expired, but it's still within the jurisdiction of the court because it was less than a year.
Okay. Ms. Corley, what are you requesting?
Well, Your Honor, first I'd like to make the court aware that most of his criminal charges were from the 90s. But the unlawful carry and what that was with a drug case, and that's why it was unlawful carry. He did have a DWI in 2005, but so it's, you know, I think 1, 2, 3 of those were in the 90s, quite a long time ago. Your Honor, we wanted you to know that basically his business was having a lot of problems during 2020, as with so many others. His income fell apart. His family was having a very difficult time. He didn't handle this especially the best way, but he didn't have money for the class, he says, and the drug testing requires money. He has begun to get back on his feet. His business is coming back up. They are doing much better financially, Judge. If you chose to revoke his probation, I do believe that his family would be able to pay the balance. I believe, and maybe Susan can confirm, I believe his balance is $1,240.
That's correct.
So that's what we would request, Your Honor. He will, if he goes into an inpatient treatment program, Judge, he will lose everything all over again.
Ms. Gross, do you have in your records the original fine on this particular case?
Yes, Judge. The original fine was $500.
State recommendation?
Your Honor, the state recommends revocation.
Mr. Holbrook can cause 575509. The court accepts your plea of true with an explanation on the second amended motion to revoke community supervision. I grant the state's motion to revoke your probation. I sentence you to 1 year in the Bexar County Jail, assess a $500 fine plus court cost, credit for time served, time and money to run concurrent. Anything further from the state of the defense on Mr. Holbrook?
Judge, if his family can pay the full balance, would you allow me to notify the court and perhaps shorten that sentence?
No, there's too much aggravation on this case. Sorry though, but I would do that if it was not a serious case, but unlawfully carrying a handgun is probably the most serious case we have in this court, as you're well aware.
Well, Judge, would you consider letting him be extended and do outpatient treatment?
No.
If he stays in jail for a year, Judge, everything's gone. I don't think that's in the best interest of the community either. And I would point out he at least hasn't picked up any new cases during this time.
None that he was caught for, certainly, that's for sure. My records reflect he has 23 days credit. Last I heard earlier this week, it was represented by defense counsel that they spoke to the sheriff's department and the sheriff was giving 3-for-1 credit on jail time. And that's all I know about the jail aspect of it. Anything further from the state of the defense on Mr. Holbrook?
No, Judge, may I go into a breakout room with my client and then be excused from there?
You bet. Good luck, Mr. Holbrook. Thank you, Ms. Corley.
Thank you, sir.
Okay, hold on. Let me, Mr. Holbrook. We had you in 2 or 3.
Okay. I can go back there.
Judge, may I give my spiel?
Absolutely. Please do.
All right. Attorneys and defendants both. Anyone that is granted and placed on probation today, you will be receiving an email within probably 48 hours to set up your orientation to sign your conditions of probation. So if you have not heard anything by Tuesday morning, you need to write down this phone number, and I will repeat it a couple of times. And you need to call the probation intake department and let them know that you were placed on probation, if you're put on probation today, and that you need an orientation date. Their telephone number is area code 210-335-7446. So if you have not received an email or a telephone call from them by Tuesday morning, you need to call them and explain to them that you were put on probation and you need an orientation date to sign your conditions. Or you can call your attorney, and your attorney can call that number, or they can call me or reach out to Miss Benavides. It is on you to make sure that you get these conditions signed. Your failure to sign these conditions will result in a warrant being issued for your arrest. Does anyone have any questions about that part? Okay, again, that phone number 210-335-7446. And secondly, this one is for both attorneys and defendants also. Is anyone currently residing out of Bexar County or the state of Texas? Or do you have any intention of moving out of Bexar County or the state of Texas? If so, before you make your plea, you need to tell the judge that you live outside of Bexar County so that he can adjudicate your case correctly. That's all. Thanks, Judge.
Thank you, Susan. Okay. The first four cases I've got at bat. Cause number 632458, State of Texas versus Benito R. Villegas Jr., represented by Russell Mitchell. Mr. Mitchell, you ready to proceed?
I believe so. My client should be there or on there.
Mr. Villegas, are you with us, sir?
Yes, sir. Yes, sir, I am.
All right,
Yes.
we're good. Thank you, sir. Next case I have is called 655-640, State of Texas versus Jonathan C. Mariscal, and represented by Mr. Gammon Gwynn. Mr. Gwynn, are you with us today?
I am, Your Honor.
All right, great.
Your Honor, he is, I don't see his defendant checked in.
Mr. Mariscal, are you with us today, sir?
He was
Yes, Your Honor.
He was a minute.
There you go. So I didn't know which one you were. Thank you very much, Mr. Mariscal. All right.
So I apologize. Did we just hear from Mr. Mariscal? He is with us?
Yes,
All right,
yes,
great.
Your Honor.
Thank you. Next case, 652-638, State of Texas versus Roxanne Monroe. Mr. Hillier, are you ready to proceed?
Good afternoon, Your Honor. Ready and present.
Thank you. And in the first batch, the last case, clause 663-603, State of Texas versus Joseph A. Hernandez, represented by Mr. Floyd Rivera. Mr. Rivera, are you ready to proceed?
Yes, sir. We both are ready to proceed, Your Honor.
Thank you. Okay, ladies and gentlemen, the first document I'm looking at on each of your cases is entitled Defendant's Consent to Plea by Video Conference that purports to have both your signature and your attorney's signature on it. Mr. Villegas, in clause 632458, is this your signature on this document, sir?
Yes, sir, it is.
Thank you. Judge Mitchell, as attorney for Mr. Villegas, is this also your signature on this document?
It is, Judge.
Thank you. Mr. Mariscal, in clause 655-640, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Mr. Gwynn, as attorney for Mr. Mariscal, is this also your signature on this document?
It is, Your Honor.
Thank you. Ms. Monroe, in clause 652-638, is this your signature on this document, ma'am?
You're on mute, Roxanne.
Sorry. Yes, Your Honor.
All right, thank you. And Mr. Hillier, as attorney for Ms. Monroe, is this also your signature on this document?
Yes, Your Honor.
Thank you. Mr. Hernandez, in clause 663-603, is this your signature on this document, sir?
Yes, Your Honor.
And Mr. Rivera, as attorney for Mr. Hernandez, is this your signature on this document also?
Yes, it is, Your Honor.
The next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. Mr. Villegas, in clause 632458, is this your signature on this document also, sir?
Yes, sir.
Thank you. And Mr. Matiscal, in clause 655640, is this your signature on this document also?
Yes, Your Honor.
Thank you. Ms. Monroe, in clause 652638, is this your signature on this document, ma'am?
Yes, Your Honor.
And Mr. Hernandez, in clause 663603, is this your signature on this document also, sir?
Yes, Your Honor.
By signing this document, are each of you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorneys, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, Mr. Villegas?
Yes, sir. Yes, Your Honor.
Thank you. Is that correct, Mr. Matiscal?
Yes, Your Honor.
Thank you, sir. Is that correct, Ms. Monroe?
Yes, sir.
Thank you. And is that correct, Mr. Hernandez?
Yes, Your Honor.
Judge Mitchell, the attorney for Mr. Villegas, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
I believe he is.
The same question for Mr. Gwynn as attorney for Mr. Matiscal.
Excuse me, Your Honor.
Thank you. Same question for Mr. Hillier as attorney for Ms. Monroe.
I do, Your Honor.
Thank you. Same question for Mr. Rivera as attorney for Mr. Hernandez.
Yes, I have, and he is, Judge.
Thank you. Mr. Villegas, are you a United States citizen, sir?
Yes, sir. Yes, Your Honor.
Thank you. Mr. Matiscal, same question?
Yes, Your Honor.
Thank you. Ms. Monroe, same question?
Yes, Your Honor.
Thank you. Mr. Hernandez, same question?
Yes, Your Honor.
Thank you. Judge Mitchell, the attorney for Mr. Villegas, has the state fully complied with discovery for you on this case?
They have.
Thank you. Same question for Mr. Gwynn as attorney for Mr. Matiscal.
Yes, sir.
Thank you. Same question for Mr. Hillier as attorney for Ms. Monroe.
They have, Judge.
Thank you. Same question for Mr. Rivera as attorney for Mr. Hernandez.
Yes, they have, Your Honor.
Okay. State, you've got a motion on Mr. Villegas' case 632458.
Yes, Your Honor. State moves to waive and abandon the .15 enhancement paragraph.
Objection from the defense, that will be granted.
No objection.
And okay, so Mr. Villegas, in clause 632458, to the charge of driving while intoxicated, first offense. How do you plead, sir?
No contest.
And is there an agreement for Mr. Villegas?
Yes, Your Honor. 12 months deferred adjudication, $500 fine, court cost, 48 hours community service, DWI education, victim impact panel, CAT SNP, Smart Start Mobile for half the term, and $60 to DPS.
And Judge Mitchell, is that your understanding of the agreement?
It is, Judge, but can I ask the court a quick question about the Smart Start?
Sure.
Due to the pandemic, he has been on the Smart Start for, I think, almost 20 months. So would the court entertain allowing me to approach the court after 3 or 4 months if he doesn't have any dirty blows to maybe not have it for the whole 6 months?
My understanding is the plea bargain calls for Smart Start mobile device for 1/2 the length of probation, which in this case would be 6 months. And it would be up to the state whether or not they want to, let's say in a perfect world with no missed blows and no high bracks for alcohol, whether the state would be interested in allowing the defendant to come off of Smart Start earlier than the 6 months that's on the plea bargain. I will say for Judge Mitchell and everybody else, every defendant's in the same shoes as Mr. Villegas with regard to having been on the Smart Start for a long time.
I know, Judge. It's been a long time.
State, I assume you want to stick with your original 6 months or half the term equation. Is that correct?
At this time, yes, Your Honor.
All right. Judge Mitchell, you're welcome to approach the state anytime in there and make your pitch. You're so good at that.
Okay. Okay. Thanks, Ms. Galloway. Maybe I'll come talk to you about 3 or 4 months.
Okay.
Any dirty blows.
Judge,
I'm sorry, go ahead.
can I throw in a footnote real quick about Smart Start for everyone?
Of course.
Anyone placed on a Smart Start that doesn't already have one, or once you are adjudicated today, contact Smart Start, let them know that you are a County Court 6 recipient, because Judge Christian has negotiated a special pay rate. And they may be able to adjust your pay, or you will get a reduced rate compared to other courts. And also make sure you get a handheld device, not one that goes in the car. Okay, handheld. There are 2 devices. There's called a Smart Start Mobile and the Smart Start Insight. You can receive either device, not one in the car. It has to be one that is handheld. That's all. Thank you, Judge.
You bet. Okay, Mr. Villegas, in clause number 632458. The court accepts your plea of no contest to the offense of driving while intoxicated. First offense. Let me back up. Yeah, that's right. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 1 year deferred adjudication probation. Assess a $500 fine plus court cost, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety new intervention program, Smart Start mobile home interlock at 4 blows a day for 6 months, $60 reimbursement to the Texas Department of Public Safety for lab testing, and recall all prior pretrial services bond conditions. Anything further from the state of the defense on Mr. Villegas?
Nothing
Your
from
Honor.
the state.
Good luck, Mr. Villegas. Thank you, Judge Mitchell.
Thanks, Judge.
Thank you, Your Honor.
Okay, Mr. Mariscal, let's see what we got going for you. State, you got a motion on this one too?
Yes, Your Honor. State moves to waive and abandon the .15 enhancement paragraph.
No objection, Your Honor.
I imagine not.
You imagine correctly.
No objection from the defense. That will be granted. Let's see, Mr. Mariscal, in clause number 655640 to the charge of driving while intoxicated. First offense. How do you plead, sir?
No contest.
Is there an agreement for Mr. Mariscal?
Yes, Your Honor.
Yes, Your Honor. 12 months deferred adjudication, $500 fine, court cost, 48 hours community service, DWI education, victim impact panel, CAT-SNP, Smart Start mobile for half the term, and regular UAs.
And Your Honor, I believe Mr. Mariscal and myself are both appreciate Ms. Galloway's offer and deal there.
Is that your understanding of the agreement, Mr. Glenn?
It is, Your Honor.
All right, all good. Mr. Mariscal, in clause 655640, the court accepts your plea of no contest to the offense of driving while intoxicated. First offense. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 1 year deferred adjudication probation. Assess a $500 fine plus court cost, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety new intervention program, Smart Start mobile home interlock at 4 blows a day for 6 months, which is 1/2 the term, and regular urinalysis tests. Anything further from the state of the defense on Mr. Mariscal?
Nothing from the state, Your Honor.
From defense, Your Honor, the only thing I would put out there is the fact that my client does not have a car and usually doesn't have access, although there is one in his residence. I'm hoping that he can use, as Ms. Gross had talked about, the portable, if that would be all right. You know, is that going to be considered the same as being in the car when you use the portable?
Yep. We exclusively use what's called a Smart Start mobile device, which is about the size of a cell phone, and it is fully portable and is not attached to the vehicle. So there's no need for a vehicle in any of our probation requirements.
Thank you so much, Your Honor.
You bet. Good luck, Gammon. Thank you, Mr. Mariscal.
Thank you, Your Honor.
Yeah.
Thank you all. May I be excused, Your Honor?
Yeah. Thank you, Gammon.
You all have a safe, healthy, and beautiful day.
Yeah, we'll give a shot to that.
Amen.
Okay, let's see what we're doing with Miss Monroe. Ms. Monroe, on cause 652-638 to the charge of driving while intoxicated, first offense. How do you plead, ma'am?
Guilty.
And, yeah, is there agreement state?
Yes, Your Honor. 12 months deferred adjudication, $500 fine, court cost, 48 hours community service, DWI education, victim impact panel, CAT-SNP, Smart Start Mobile for half the term, regular UAs, and restitution, if any, to Cortland Brackenridge Apartments.
Let me do some writing here. Did we run into the apartments?
Yes, sir.
All right. Well, I'm sure that was exciting while it lasted. Mr. Hillier, is that your understanding of the agreement?
It is, Your Honor.
Ms. Monroe, on cause 652-638, the court accepts your plea of guilty to the offense of driving while intoxicated, first offense. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 1 year deferred adjudication probation. It says a $500 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile, home interlock at 4 blows a day for 6 months, regular urinalysis test, restitution, if any, to Cortland Brackenridge Apartments. I assume that's in San Antonio, Texas. Is that correct?
Yes,
That's
Judge.
correct, Your Honor.
Okay, anything further from the state of the defense on Ms. Monroe?
Nothing from the state, Your Honor.
Nothing from the defense, Judge.
Mr. Hillier, I forgot to add, is that your understanding of the agreement?
It is, Judge.
Let me go through and make sure we get this straight. Ms. Monroe, on cause 652-638, the court accepts your plea of guilty to driving while intoxicated, first offense. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 1 year deferred adjudication probation. Assess a $500 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile home interlock at 4 blows a day for 6 months, regular urinalysis test, restitution, if any, to Cortland Brackenridge Apartments in San Antonio, Texas. Okay. Anything further, Mr. Hillier?
Nothing from me, Your Honor.
Anything further, state?
Nothing from the state, Your Honor.
Good luck, Ms. Monroe. Thank you, Mr. Hillier.
Thank you, Judge. Have a good day. You can log off, Roxanne.
And let's see what we're doing with Mr. Hernandez. And is this our starting out as an obstruction, or are we going to have to do motions to get it to an obstruction?
The state needs to make a motion, Your Honor.
What did this start out at? DWI greater than 1.5? Nope, that's a different case.
No, a
it's a
DWI, Your Honor.
DWI.
Okay, I got you. Start out at DWI first. So, state, go ahead and make your motion.
Yes, Your Honor. State moves to amend the charging instrument to add an obstruction paragraph.
The defense has no objection to that.
State's motion to amend the information, adding paragraph 2, alleging obstruction of a highway. No objection from the defense is granted.
Yes, Your Honor. The state moves to waive and abandon the DWI paragraph.
Once again, no objection from the defense. State's motion to waive paragraph 1, alleging driving while intoxicated, first offense, and proceeding on paragraph 2, alleging obstruction of a highway, is granted. So this time, Mr. Hernandez, the charge of obstruction of a highway. How do you plead, sir?
Guilty.
An agreement for Mr. Hernandez.
Yes, Your Honor. 14 months deferred adjudication, an $850 fine. We ask that the court probate $250 of that fine. Court cost, 48 hours community service, DWI education, victim impact panel, CAT-SNP, Smart Start Mobile for half the term, regular UAs, DOEP class, anger management class, $60 to DPS, and a letter of apology to Officer Zimmerman.
I think I have the authority to order somebody to write a letter of apology. Mr. Rivera, is Mr. Hernandez volunteering to do that?
Yes, he is, Judge, and here it is.
Thank you. And I'm going to word it on our order that the defendant agrees to write a letter of apology. Is that okay with the defense?
That is okay with us, Judge.
And state, when we're talking anger management, we're talking APSE. Does that sound right?
That's correct, Your Honor.
Good. And Mr. Rivera, is that your understanding of the agreement?
Oh, yes, it is, Judge.
Let's make sure I get it right.
Yes, sir.
Mr. Hernandez, in cause 663-603. The court accepts your plea of guilty to the offense of obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 14 months, deferred adjudication probation, assess an $850 fine, probating $250 of that, plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety new intervention program, Smart Start Mobile times 4 blows a day for 7 months, regular urinalysis tests, DOEP course, APSE stress management or anger management course, $60 reimbursement to the Texas Department of Public Safety for lab fees, and a letter of apology to Officer Zimmerman, it looks like. Does that sound right, State?
That's correct, Your Honor.
Is that SAPD officer?
Yes, it is.
Yes, Your Honor.
Okay, that's what we got. Anything further from the state of the defense on Mr. Hernandez?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Good luck, Mr. Hernandez. Thank you, Mr. Rivera. Y'all are excused.
Yes, sir.
Your Honor,
Yeah.
you need to sign the paperwork for Via Vincencio. And
Okay,
get it to you. It's ready.
let's take a 5-minute break while I do that and get that all figured out.
Okay.